Hello students, I hope everyone is ready for your examination. So we can have a discussion on the major amendments which is applicable for June 2025 examination. So as we discussed in our amendment videos, I have included all the amendments which has taken place in the couple of years so that all the students who are writing the exam after a small gap will also be benefited from this discussion. Okay, so we'll first move to the segment of Competition Act. So in Competition Act, there are two amendments. One is threshold of combination has been amended. Number two, with respect to anti-competitive agreement, we have a small change in the term exclusive supply agreement. We know that in vertical agreement, there was exclusive supply agreement. It is now changed to exclusive dealing agreement. So first of all, we'll move to the change in thresholds of combination under section 5. So the amended thresholds are, it was earlier 2000 crore, more than 2000 crore in assets and more than 6000 crore in turnover. Now it has been amended to more than 2500 CR and turnover is more than 7500 CR. Then your if it is a group, it will be more than 10,000 CR and more than 30,000 CR in the case of turnover. As you know that turnover will be 3 times with that of your assets, and individual and group, if individual is 2500, it will be 4 times, group will be 4 times. So earlier it was 2000 and 8000 in the case of individual and group. Now it is 2500 for individual and 10,000 for group. Then in the case of if enterprise has assets or turnover outside India, it will be more than 1.25 billion, and minimum component Indian component is now amended from 1000 crore to 1250 crore. Okay, then in the case of turnover more than 3.75 billion and Indian component is 3750 crore. In the case of group, more than 5 billion and minimum 1250 crore in India. Indian component is same in both cases. Okay, so more than 15 billion and minimum 3750 crore in the case of group having assets or turnover outside India also. Okay, so earlier it was 2000 in the case of individual, now it is 2500. So automatically the group or the turnover will be changing to 7500 from 6000, because as we discussed, it is turnover will be 3 times of what the figure is in your assets. Okay. Then the second amendment with related to the Competition Act is the change in term of exclusive supply agreement. So in vertical agreement, it was supply agreement, exclusive supply agreement term was there. It is now changed to exclusive dealing agreement. Okay. Now we'll move to the second segment, which is related to incorporation of companies. Under this chapter, we are having three amendments. Number one is related to small company. This amendment took place 3 years before, but now, even now, I have included the same. Then in the case of resident in OPC, which was amended after COVID-19, then conversion of OPC also. So with respect to the definition of small company, if a private limited company whose paid up capital does not exceed 50 lakh and turnover does not exceed 2 crore, which is the definition given in section 2 clause 85. Okay, so when we are explaining the same with the corresponding rules, the rules companies specification of definition details rules specifies that small company is a company whose paid up capital does not exceed rupees 4 crore or such higher amount as may be prescribed, and the turnover does not exceed rupees 40 crore. Okay, so in definition, you have to understand that in definition under clause 85 of section 2, 50 lakh and 2 crore will be given. But in rules, it is clearly given that the paid up capital threshold for small company is now 4 crore and turnover threshold is 40 crore. Okay. Then with respect to the resident concept in OPC, before COVID-19, OPC can be incorporated only by natural person, Indian citizen and resident in India. Okay, now it has been amended. The person, the sole member of OPC or nominee of OPC can or cannot be resident in India or may not be resident in India. So in December 2024, a question was asked with respect or from the chapter one person company or from the area one person company. So it is that question was also related to this concept. So it is not necessary that the sole member and or the nominee should be resident in India. They may or may not be resident. Okay, then the term resident in India is explained as person who has stayed in India for minimum 120 days. It was 182 days. Now it has been changed to 120 days. Then with respect to the conversion of OPC, OPC can be now converted to private or public at any point of time. Earlier there was a rule specifying that OPC can be converted to private or public only after 2 years or whether their paid up capital is exceeding 50 lakh or when their turnover is exceeding 2 crore. Now that provision has been omitted. Now your OPC can be converted to private or public at any point of time. Okay. Then we'll move to the amendments or the changes related to in connection with meetings of board and its powers. So one is related to the thresholds of RPT, related party transaction, then omitting of rule 4, then changes in audit committee and nomination and remuneration committee. So with respect to the related party transaction, there are two concepts. You will be requiring, if you are doing a related party transaction, you will be requiring board's resolution or board's resolution plus ordinary resolution. So there are situations where ordinary resolution is required. So when the transaction is related to sale, purchase or supply of material, if the aggregate or individual transaction is amounting to 10% of turnover, you will be requiring ordinary resolution. If it is related to disposing or buying of property, it is 10% or more of net worth. Leasing of property amounting to 10% or more of turnover. Availing or rendering of any services, 10% or more of turnover. So in your material, you will be seeing different thresholds. It was the old threshold. Okay. This threshold has been amended as I mentioned before 3 or 4 years before, but even in your material, it is now giving the old threshold. That is why I have included this provision in our discussion. Okay. Then rule 4, which is related to in meetings of board and its powers, rule 4 was related to matters that cannot be discussed in VC or OAVM. Only these topics could be discussed if physical quorum was present. That is, if the quorum is present, if the quorum of board meeting is present physically, these matters could be discussed. Okay, without physical quorum, these matters could not be discussed. But after COVID-19, this rule number 4 has been omitted. So any discussion can now be discussed through VC or OAVM. Physical quorum concept or the satisfaction of physical quorum is now not mandatory. The non-applicability of audit committee and NRC. This provision is applicable to independent, the concept of independent directors also. So we know that independent directors, audit committee, NRC is applicable to listed company or unlisted public company having paid up 10 crore or above or turnover 100 CR or above or having aggregate outstanding loan debenture deposit in excess of 50 crore. Okay, the provisions are same for applicability of independent directors, audit committee and NRC. But now, when these provisions are applicable to an unlisted public company, and if that unlisted public company is failing to meet these thresholds in the sense that paid up 10 crore, turnover 100 CR, or aggregate outstanding loan plus debenture plus deposit in excess of 50 crore for 3 consecutive financial years. Means once the provisions are applicable and after that for 3 consecutive years, none of these provisions became applicable, then you need not constitute audit committee or NRC in the next financial year. Okay, So the provisions of audit committee, NRC, independent directors will not be applicable to such unlisted public companies till it meets the criteria again. Okay, so once the provisions are applicable, the concept of independent director, audit committee, NRC will be applicable. So after making this provision applicable, if these thresholds are not met through 3 consecutive financial years, the provisions will not be applicable till it meets the criteria again. Okay. Then provisions or amendments related to acceptance of deposits. One is the concept or the change in percentage of deposit repayment reserve, then acceptance of deposit by private limited company, and waiving off of deposit insurance. That is also there. So, with respect to deposit repayment reserve, minimum 20% of the amount to be maintained. It was earlier 15%, now it is 20%. And deposit repayment reserve has to be maintained on or before 30th of April. Then, with respect to acceptance of deposit by private limited companies, they can accept up to or maximum of 100% of paid up free reserves and securities premium. Okay. Now, the amendments related to Insolvency and Bankruptcy Code 2016. So, one is filing of application under Section 7, which was amended in 2019. Then, person who cannot initiate insolvency resolution, Section 11, which is very important. And you can see that that question was being asked in the last examination also. So, this question will be, this is a repeated kind of question, Section 11, and which is normally asked in that descriptive sense only. Okay, so we'll move to the section amendment in section 7. So in the case of financial creditors related to debt or securities, debentures, other securities, etc., application shall be filed by 100 financial creditors or 10% of such creditors, whichever is less. Okay, so if the financial creditor is related to debentures, debt, securities, etc., if they want to initiate corporate insolvency resolution process against the corporate debtor, their application will have to be filed by either 100 financial creditors or 10% of the total creditors of that particular class, whichever is less. Then persons who are not entitled to make application under section 11 of Insolvency and Bankruptcy Code, corporate debtor undergoing CIRP, corporate insolvency resolution process, or pre-packaged insolvency resolution process. Financial creditor, operational creditor, or corporate debtor undergoing pre-packaged insolvency resolution process. Corporate debtor having been completed CIRP 12 months preceding date of application. Corporate debtor in respect of whom a resolution plan has been approved 12 months preceding date of application. Corporate debtor or financial creditor who has violated the terms of resolution plan approved 12 months before date of application. Corporate debtor in respect of whom a liquidation plan or order has been passed. Okay, so which I have given in red has been amended. Okay, then we'll move to the provisions which are related to SEBI. So two amendments are from SEBI, prohibition of insider trading regulation, person deemed to be connected. There is a small change in the definition. Then in trading plan also, there is a small change. Then person not eligible to make IPO, FPO, the concept or the change related to fraudulent borrower, lock-in period for excess over minimum contribution, appointment of monitoring agency. So first we will discuss the person deemed to be connected person. So when we are discussing the concept of a connected person deemed to be connected, it was giving 10 points like immediate relative was there, holding company, associate company, subsidiary company, then intermediary under section 12 and so on. 10 particular points were there. So now SEBI regulation has amended immediate relative. Now it is only relative of connected person. Okay, so the definition of relative of connected person includes spouse of person, parent of person or spouse, then sibling of person or spouse, child of person or spouse, then spouse of point number 3, spouse of sibling, then spouse of your children also. Okay, so this is the amendment which is made. That is immediate relative was a point. Now immediate is removed, it is only relative. Then two more provisions are added. There were 10 points. Now we are having 12 points. Okay. Point number 11 is a firm or partner or its employee in which connected person is a partner. Then last point, point number 12, a person sharing household or residence with the connected person. So these changes are in persons who are deemed to be connected. Other points are remaining the same. Earlier we were having 10 clauses. So out of that only immediate relative, the word immediate has been removed. Okay. The remaining 9 clauses are the same, plus you are having 2 other clauses. One is firm or its partner or its employee in which connected person is partner, a person sharing household or residence with the connected person. Then with respect to trading plan, we were having 4 points. So the in first point, trading plan can be executed. It was 6 months after public disclosure. Now it is 120 days. 6 months have been removed. Now it is 120 days. And point number 2, trading plan could not be made during the period. Trading could not be made during the period from 20th trading day prior to last day of financial period and second trading day after disclosure of financial result has been removed, that has been omitted. Plan shall be for minimum of 12 months, that point is also now omitted. Two trading plans cannot be overlapped. So only 2 points are there, and out of which in the first point 6 months have been changed to 120 days. Okay, so these are the major changes in SEBI prohibition of insider trading regulation. Even now there are amendments. So those amendments are applicable in the month of June only. So that is not applicable for your June examination, which will be applicable for your December term of examination. Then in SEBI ICDR regulation, willful defaulter shall be substituted by willful defaulter or fraudulent borrower. Amount for general corporate purpose and unidentified acquisition purpose shall not exceed 35%. Promoters lock-in period is now reduced to 18 months from 3 years. So many students used to ask me the question, in material it is shown as 3 years. It has been amended. It is now 18 months. 3 year was cut to 18 months. Then lock-in period for amount exceeding promoters contribution reduced to 6 months. So for promoter contribution it is 18 months, and for excess over promoter contribution from 1 year it has been reduced to 6 months. Credit rating agency to be appointed as monitoring agency if issue size exceeds 100 CR. It was earlier banking or financial institutions, now it is CR. Then monitoring agency in IPO. So credit rating agency will be appointed as monitoring agency in the case of IPO or FPO. They have to submit report every quarter till 100% of the receipts are utilized. It was earlier 95%. Now it has been amended to 100%. Then we'll move to the last part of amendment, which is related to Information Technology Act. Okay, so last attempt in December 2024, we were having a question related to the effectiveness of punishment in Information Technology Act. So there are two sections, 43A and 72A. Now in 72A, there was the penalties like, it was like 3-year imprisonment or 5 lakh or both. Now it has been amended. The penalty will be up to 25 lakh only. So this is in 72A of your Information Technology Act 2000. Okay. So these are the major amendments which are applicable for your June 2025 examination. So you have to take care that in trading plan, some amendments, major amendments took place in SEBI prohibition of insider trading regulation. So one is related to relative. Immediate relative is now changed to relative, and your trading plan has undergone certain changes. 2 points are omitted, and 6 months is now changed to 120 days. Okay, so these are the major topics. Okay, I think the discussion is clear. So all the very best for your examination in advance. Thank you.